All right, also joining us on the program at this point in time is Arvind Kumar Jain, former DGP, UP Police, Rudra Vikram Singh, Advocate Supreme Court, is also with us on the program. Well, we've heard from Tusha's friends, we've understood what kind of a person she was, and we still are not able to wrap our heads around as to why would something like this happen to her. Arvind Kumarji, what have you made out of the case and how it was handled? Now that it's gone to the CBI, there is obviously this faction that believes that the case was manhandled.
Yes, mishandling was there. One thing is very funny, I can't see your face also. The screen is blank. This has never happened. I can't even see the anchor.
That's okay, sir. I can hear you.
Anyway, so I think there was mishandling either due to some pressure from the mother-in-law's side or because she was a retired district judge. But there was mishandling, and I think the right step has been taken. That investigation has been handed over to CBI now, and CBI, in my opinion, will do a good job. It's also very commendable on the part of MP High Court that they allowed the second postmortem by a team of doctors from AIIMS, Delhi. And once the report comes out, so many things will be clear. Because in the first postmortem, even the belt was not sent for examination. And ligature marks, there were two ligature marks, parallel ligature marks. How come there were two marks? So naturally there was some confusion. And in my opinion, anticipatory bail should not have been granted the same day to the lady, to the mother-in-law, because it's a case of dowry death and it's not a joke. And action should have been taken by Madhya Pradesh, Bhopal police. In such cases, generally we used to take accused in preventive detention so that they don't escape. It was not done by Bhopal police. I don't know what is the reason. Now things will gradually come out, and I think second postmortem report will reveal so many things, and Supreme Court is also monitoring it. And I'm very happy that Solicitor General appeared in MP High Court to oppose the anticipatory bail to Samarth Singh. This was an important step that SG was roped in by MP government. Right step was taken. This is what I think, that now things should progress, because now CBI will register a fresh case and they will start investigation. Today I was seeing on TV channel that Samarth Singh has been taken to the scene of crime by SIT for recreation of the crime scene. So now I think they are acting, they are moving and in the right direction. This should have been done long time back.
All right, Rudra Vikram Singh, Advocate Supreme Court, with us on the program as well. Rudra Vikram Singh, it's important to understand that a lot of things that happen at the beginning of this case do not leave a good impression of the way justice was supposed to be carried out. The police also determining too quickly at the start that this was a suicide. Now there's been a second postmortem. The Supreme Court has also taken cognizance of this case. What have you judged from all these anomalies that we've been seeing related to this case?
See, before analyzing all these things, I would state what Supreme Court has said today. Supreme Court has clearly stated that the accused persons who are coming into the TV channels, who are giving bites to the media, should refrain from doing this. And the kid and kin of the complainant side should also refrain from doing anything, saying to the media, because they are the key witnesses of this case. Whosoever are the kid and kin of, from the complainant side, from the victim side, they are the key witnesses in this prosecution case, and that could harm the prosecution case. This is the criminal. This is to understand the criminal jurisprudence, because once you said everything on TV, once you said everything on any channel or any news paper, so the prosecution, the way of investigation by a prosecution agency it's kind of their own way of style for doing investigation. So whatever police has said it in the early stages that this was suicide, that was also wrong. They should have not stated. They should have not come with this statement that this was suicide, because without doing any investigation, without doing any proper investigation, you cannot state that this was a case of suicide. Once you complete your investigation, file the charge sheet against the accused person, everything will be revealed, that what was it suicide, was it dowry death, or was it anything else. Secondly, the mother of the accused, the main accused, the husband of the deceased, was also making many statements through media, through other channels. She should also stopped by Honorable Supreme Court. She was advised that you should also not come before the media and should not say anything. And earlier, whatever she was doing, that was not appropriate. Now I'll come to the case. See, when we start saying anything supporting to the accused or the supporting to the complainant without going into merits of the case, without knowing what is the investigation, without concluding the investigation, it is prejudice to the investigation. Also, it is prejudice to the justice, which will be delivered to the victim. So we can only say what is the law. I can only tell you what is the law. If that would be the dowry case, if that would be the suicide case, what would be the law. I cannot say that whether Twisha has did wrong, whether their family person has did wrong, because
All
sitting
right.
here
All right.
and
Rudra, we've run out of time, but I appreciate your thoughts on this. I appreciate your perspective also.